It's my honor to be the chair of this panel. This panel, we have 3 speakers, all of them from China. And we hope they give us a very comprehensive perception of trade dispute resolution. I think they give us different presentation from different perspective. And Professor Chen from Fudan University focused on foreign arbitration institutions. And Professor Bingwan from Renmin Law School focused on WTO legal rules interpretation. And Professor Hu from Shanghai Jiao University gave us a presentation about One Belt, One Road initiative. Okay, welcome. And I hope every speaker have 20 minutes at most. Okay. Professor Chen. Yeah.
In the last minute.
Okay.
Okay, good afternoon, everyone. It's my great pleasure to deliver a speech here, and this is the second time I come to Copenhagen. I was here 1 year and a half ago as a visiting scholar for a very short visit, 1 month. It's not very short. And I spent the beautiful summer holidays in Copenhagen. And this time, of course, is in winter, but it is still a very beautiful season here. And okay, so my topic today is: can foreign arbitration institution administer cases seated in the PRC? I mean the mainland China. Okay, so I think this topic is also attract the interest of Professor Zhao Xiuwen, and she will give a presentation tomorrow in another session. So we have the same topic, but possibly different opinion on the same issue. Okay. So before I make the presentation, I would like to ask you: can foreign arbitration institution administer cases seated in your country? For example, in Denmark, is it possible? Is it allowed? Or in Norway? Or in any other countries? Is it allowed? Possibly, I think your answer is yes, no problem. But why? In China, it's a big issue, I think. Okay, it's still under controversy today, until today, okay? So as we know that, I will give you a background to the Chinese Arbitration Law. Chinese Arbitration Law actually was adopted in 1994, 24 years ago, and has not been revised so far. However, in recent years, with the rapid growth of international trade and investment in China, some new arbitration issues has emerged and bring great challenge to the current Chinese arbitration law. Here I give you 2 examples. One example is there are some reported cases regarding whether purely domestic disputes without any foreign element can be submitted for arbitration by foreign arbitration institutions outside China. In recent years, more and more Chinese companies, the companies with the Chinese nationality, they would like to submit their disputes for arbitration outside China to the foreign arbitration institutions. Many cases has been reported, okay? And maybe this question is also very easy for you to answer. If there is a disputes without any foreign elements or purely domestic arbitration disputes, which of course can be submitted for arbitration outside your country. But in China, the answer is no. That means so far China still, for the purely domestic disputes, is not allowed, the parties are not allowed to submit such kind of disputes for arbitration outside China. So now the Supreme People's Court has taken a very consistent approach on this issue. But today I will mainly focus on the second issue. The second one is we also have some reported cases for the foreign related cases. You know, in China, we adopt the so-called three elements test to determine whether it's a purely domestic case or a foreign-related cases. And there are some reported foreign-related cases in which parties choose foreign arbitration institutions to administer arbitration seated in China. For example, the parties, disputing parties, they choose ICC. ICC is a foreign arbitration institution, but they choose designate the arbitration place in China, either in Beijing or in Shanghai. Is it allowed? So that's the first question I ask you when I start my presentation here. And of course, in practice, in the academic community, there are also significant controversies on this issue with dividing opinions. And even in the Supreme People's Court in China, I think they also adopt a different opinion on this issue. Okay, so this is the main issue I want to discuss today. So there are two possible ways for foreign arbitration institutions administer arbitration in China. The first way is the foreign arbitration institutions establish branches in the PRC to administer arbitration. Okay, so this is the first way. And of course, there are different opinions on this, whether foreign arbitration institutions can arbitrate, can set branch in China. There are two different opinions. One opinion is some scholars consider that based on the positive list of market access and the promise of market access in the Chinese protocol on the accession of the WTO and the GATS trade in service, commercial arbitration service is not on the access list. Therefore, foreign arbitration institutions are not allowed to administer arbitration inside the PRC. So this is one opinion. Another opinion is some other scholars just argue that the service of foreign arbitration institutions does not fall within the scope of transnational trade in service, and China should have an open attitude. That means, of course, the foreign arbitration institutions can administer arbitration in China. So two different opinions on this issue. How about the practice? You can find that in the year of 2015 and 2016, Hong Kong International Arbitration Center, Singapore International Arbitration Center, and ICC have established representative office in Shanghai Free Trade Pilot Zone. Okay, and although they are established under the PRC laws and registered at the Administration of Industry and Commerce, however, their activities are subject to the restrictions of PRC law. That means they are not allowed to do business. Okay, they can only engage in communications, market services, consultations, and other non-business operations. So this is the current situation and the situation of practice in China. So this is the first way. And I would like to pay more attention in the second way for the foreign arbitration institution administer arbitration in China. The second possible way is foreign arbitration institutions administer arbitration based on parties' arbitration agreement with a seat of arbitration in PRC. That's the example I gave you. The disputing parties, they choose ICC. However, they choose ICC to arbitrate in China. Is it allowed or is it permitted? Is it possible in China? That's the main issues Chinese legislators and the Supreme People's Court are facing today. So here there are some reported cases relating to this issue. I would like to give you two earlier cases. The first case is Zubling case. Of course, Zubling is a German company, right? This is a very famous case in 2003. And in this case, the Supreme People's Court decided that arbitration clause should be deemed invalid on the ground that the parties did not clearly designate the arbitration institution. Because in this case, the parties only choose to use ICC rules to arbitrate in Shanghai. And according to the arbitration law, Article 16 and Article 18 of the Chinese Arbitration Law, if the parties did not designate a specific arbitration commission, then the arbitration agreement will be invalid. So this is the main reason why in this case, the Supreme People's Court finally decided that this is an invalid arbitration agreement. Okay, and in the second case is also a very famous case and influential case in the year of 2009. But this case was made by the Ningbo Intermediate People's Court. And in this case, the Ningbo Intermediate People's Court finally decided that the award rendered in the PRC was a non-domestic arbitral award and recognized and enforced such arbitral award according to the 1958 New York Convention. And in this case, the parties, they also choose ICC as the arbitration institution. But the seat of arbitration is in Beijing. There's no disputes as to the jurisdiction of the arbitral tribunal at the very beginning. And after the arbitral award was made, when the sole arbitrator is a foreigners, compose the sole arbitral tribunal and hear the case, make a final awards. And this awards is against the Chinese company and in favor of the, I think it's a Switzerland company. Okay, but the Chinese company did not perform the arbitral award automatically. So the foreign company applied for recognition and enforcement of these arbitral awards to the Ningbo Intermediate People's Court. And the Ningbo Intermediate People's Court deemed this award as a non-domestic arbitral award and finally recognized and enforced it according to the New York Convention. So after this case was reported, there's also a lot of different opinions on the decision of the Ningbo Intermediate People's Court. Okay, so these two cases are the early cases reported relating to the foreign arbitration institution arbitrate the disputes in China. However, in neither case did the courts provide specific judicial opinions on the validity of such arbitration agreements. Okay. Then we move to the year of 2013. There are three very interesting cases. But in my opinion, is the Longlet case and the Beilun case, actually the decision in both cases is conflict with the case, with Shanghai case. Three cases are all made in 2013 and was made by the Supreme People's Court. And in the first two cases, the Supreme People's Court recognized the validity of the arbitration agreements where the parties to foreign-related disputes choose foreign arbitration institutions with the seats of arbitration in China. And both cases, the parties choose ICC, still ICC. Okay. But in the second case, the Supreme People's Court made a narrow interpretation of the Arbitration Commission under Article 20. Of course, I can tell you the background. The Longlet case and the Beilun case, actually, the Supreme People's Court mainly interpret Article 16 instead of Article 20. But the Shanghai case, the court make an interpretation to Article 20 of the arbitration law. And also gave the Arbitration Commission, used in the Chinese Arbitration Law, this case gave a very narrow interpretation. That means the Supreme People's Court finally decided that Arbitration Commission established under Article 10 and 16, 66 of the arbitration law did not include foreign arbitration institutions. However, in the Longlet case and the Beilun case, the Supreme People's Court finally considered that Article 16, the Arbitration Commission used in Article 16, include foreign arbitration commission. So, do you think that these three cases, they are mutually conflict with each other? Okay, so this is the attitude of the Supreme People's Court in the three cases. Here I also show you the relevant articles here in Article 16 and Article 18. According to these two articles, we can conclude. We can have a conclusion that we can answer the question: Is arbitration commission used in Chinese arbitration law include foreign arbitration institution? From the Longlet case, the answer is yes. But from the Shanghai case, the answer is no. That That means in the same year, the Supreme People's Court, they make different decisions, okay, different interpretations to interpret the arbitration commission used in Chinese arbitration law. And you know that Chinese arbitration law is very special, since Chinese arbitration law only admit institutional arbitration instead of ad hoc. That means ad hoc arbitration so far is not allowed according to the current Chinese arbitration law. Okay, and to select arbitration commission is one of the critical requirements for determining the validity of arbitration agreement. So this is very important. That means if the disputing parties, they didn't designate a specific arbitration commission in their arbitration agreement, and they cannot make a supplementary agreement, then such arbitration agreement will be deemed invalid. Okay, so in these circumstances, the question of whether an arbitration agreement providing for a dispute to be administered by a foreign arbitration institution with a seat in the PRC is valid or not largely depends on the interpretation of the arbitration commission referred to in Article 16 of the arbitration law, and the overall understanding of the legislative background and the framework design of the arbitration law. I think the Chinese Supreme People's Court, they possibly use a different interpretation approach in different cases. So how to interpret the legal terms used in the arbitration law? In this case, in my presentation, normally how to interpret the arbitration commission used in the Chinese arbitration law. I think there are several interpretation approach to interpret the legal terms used in the laws. The first one is the literal interpretation. Of course, from the literal meaning of arbitration commission, you can find that Chinese arbitration law use the special term arbitration commission instead of arbitration institution. So this is a very special legal term, arbitration commission, but not a generally arbitration institution. But you can find that in some other laws, especially the Chinese conflict of laws, we use a general term, arbitration institution, instead of arbitration commission. So this is one thing I would like to remind you to pay attention. And in the Langlai case and the Beilun case, the Supreme People's Court, instead of dwelling on the literal meaning of the term in Chinese, construed the arbitration commission used in Article 16 of arbitration law as a general reference to the arbitration institutions. So my personal opinion is, as a general principle, it is acceptable for the Supreme People's Court to avoid a rigid interpretation of terms under laws by giving an expansive or flexible interpretation of the terms. However, its interpretation should not exceed the original intention of the legislation. So that's the key in this issue. Although the outcome of the Langlai case is welcomed, of course, by the international business world, okay? The reasoning applied by the Supreme People's Court in that case was not without issues. In the Langlai case, the court's extended interpretation of the arbitration commissions under the arbitration law to include foreign arbitration institutions has gone beyond the original intention of the legislation. This is my personal opinion. So why? So if you find that from the purpose of the Chinese 1994 arbitration law, you can find that the spirit of the 1994 arbitration law is, the main purpose is to separate the arbitration commissions from the administrative organs. This is the main purpose. It leaves no room for foreign arbitration institutions to arbitrate in China. If you read the arbitration law as a whole, you can find that it leaves no room for foreign arbitration institutions to arbitrate in China. Okay, and pursuant to the overall provisions, actually you can find the arbitration commission, the legal terms used in different provisions under the Chinese arbitration law. Arbitration commission used in the arbitration law only refers to the arbitration institutions established according to the Chinese law within the territory of China, and excludes those foreign arbitration institutions established outside of China. So this is my overview with the legal terms used in the Chinese arbitration law. Okay, and another opinion of mine is I think that the word arbitration commission used by the arbitration law is a legal term, which should be interpreted consistently to ensure it has the same meaning under the different articles. You cannot see that we gave a narrow interpretation to Article 16, but we gave a broad interpretation to Article 16, but gave a narrow interpretation to Article 20. This is not a systematic interpretation. So I think we should use the holistic or systematic interpretation approach to interpret the legal terms under the Chinese arbitration. If we use this approach to interpret arbitration commissions under the Chinese arbitration law, then the conclusion is very clear. That means the Chinese arbitration commission used the arbitration law exclude the foreign arbitration institutions. That means even the parties they choose foreign arbitration institutions to arbitrate in China, such arbitration agreement will be deemed invalid. Okay, so I don't want to explain more in detail. And another conclusion I want to make is that if we don't make a systematic explanation to the interpretation to the arbitration commission, possibly we will lead to a consequence that the laws could not be implemented. Since time limit, I cannot explain further. I give you 3 situations. If we didn't use a systematic approach to interpret the arbitration law, then the laws cannot be implemented actually. This is a very serious consequence. Okay, so the last one is I think that Chinese arbitration law have to make a revision since 24 years has passed, and the law was adopted in 1994, and that time China has not acceded to WTO. Okay, not acceded to WTO. So we haven't taken the foreign arbitration institution into consideration that time. So the Supreme People's Court tried to give a flexible interpretation and expand the interpretation. The purpose is good. Want to support international arbitration. However, the judicial interpretation must be subject to the real intention of the legislation or legislator. So the way to the reform, I think, is finally, I think we have to make a reform of Chinese arbitration law from the institutional arbitration oriented to the arbitration seat oriented. Okay, so I'm sorry for spend more time to make my presentation. Thank you very much. Okay.
Thank you, Professor Chen. We have already one possible answer to this question, and may we have another and a different answer to this question, more given by Professor Jiao. And thank you, Professor Chen, again. Now, Professor Xiong, yeah, please.
Okay. Thank you very much, Professor Han, and I'm very happy to come back again to Copenhagen University Faculty of Law to briefly introduce some of my recent studies as to the legal interpretation methodology of the WTO DSB's panels and the appellate body. And I'm very grateful to Professor Han and Bing and also Joanna for their previous help and advices for my study here. And so my work is basically about the question as to how do contextual elements and the judges' political preferences interplay during their interpretation of WTO covered agreements. So Professor Chen Li just talked about the literal interpretation by domestic courts of international treaties. So my reflection will move to the arena of international court. So in the long history, for the past few, perhaps 2 decades long of the WTO DSB's interpretation practice, both the panels and the appellate body has taken contextual interpretation as a foundation for its whole interpretation activity. So the basic logic is that the contextualized ordinary meaning helps to promote the predictability and the stability of the whole legal system of WTO covered agreements. But my finding tells quite a different story. So if we have a closer look at those panel reports and those appellate body reports as regard to some of those most recent cases relating to China rare earth and China raw materials, perhaps we could find a puzzling situation. So what is puzzling is that we can see in the three recent cases, China raw materials and China rare earth, we could see that if we combine those reports together, we can see the so-called objective contextual interpretation presents, however, two sets of competing contextual arguments. So that brings the following questions: what is really going on behind those competing contextual arguments? So the problem that makes it more serious is that the shortage of a superior rule that could govern adjudicators' choice and understanding of those contexts will make it even more problematic to foster a stable and a predictable system for the whole WTO covered agreements. And so here what I'm going to do is to try to briefly present the two sets of competing arguments. So in each set of contextual arguments, we can see four sub-arguments. And I will try to present the competing situation of those two different situations. The case of the issue in this dispute is about China's imposition of export duties, together with many other measures on raw materials and rare earth in the later case. It's obvious that the imposition of export duties by Chinese government is inconsistent with China's acceding commitment made in paragraph 11.3 of China's accession protocol. So in this accession protocol, it says that China shall eliminate all taxes and charges applied to exports unless specifically provided for in Annex 6 of this protocol or applied in conformity with the provisions of Article 8 of GATT 1994. The central issue for those two cases is whether China is entitled to invoke the general exception clause in GATT 1994, the Article 20, as a defense to justify its inconsistent, its measures inconsistent with its commitment in its accession protocol, paragraph 11.3. So here we can see that the GATT Article 20 is the article that the Chinese government would like to invoke to justify its measures. And at the end of Article 20, it says that nothing in this agreement shall be construed to prevent the adoption or enforcement by any contracting party of measures. And the subsection B is about the case China rare earth is one necessary to protect human, animal, or plant life or health. And the next subparagraph is number G, which is related to China raw material case. It's relating to the conservation of exhaustible natural resources if such measures are made effective in conjunction with restrictions on domestic production or consumptions. So here is what the relationship between protocol paragraph 11.3 and the general exception in GATT Article 20. And in resolving those cases, we can see that in the first case in China raw materials, both the panel and the appellate body unanimously ruled against China that China is not entitled to invoke Article 20 to justify its exceeding obligation inconsistent measures. Whereas in the second case in China, rare earth, we can see that there is in panel decision, there is a dissenting panelist who held that China is entitled to invoke Article 20 to justify its measures. So here we can see that there are four, if we combine all of those arguments employed in those reports and some other academic literatures, we can see that there are four opposed pair of contexts. The first pair of contexts is about how to construe the absence of a textual link between GATT Article 20, I mean the general exception clause, and paragraph 11.3. So the majority of the two reports, I mean the judges, hold that absence equates to waiver, since there is no textual link in paragraph 11.3 to GATT Article 20. There is no express link, which means that the government has no intention to invoke that special clause. So one evidence that supports the majority is that in some other paragraphs, there are express textual link between GATT Article 20, I mean those general exceptional clauses, and those measures at hand. One evidence is paragraph 5.1 of the protocol. So it said at the very beginning that without prejudice to China's right to regulate trade in a manner consistent with the WTO agreement. So in that case, in the case China publication and audiovisual products, the appellate body ruled for China's measures against its protocol, because there is a express cross-reference in the beginning of 5.1 paragraph. But the dissenting panelist made a different argument. It says that absence does not necessarily mean a waiver of exceptional invocation. So you can see that in previous AB reports, like for in Canada Auto, the appellate body said that omissions in different contexts may have different meanings, and omission in and of itself is not necessarily dispositive. And in another case, United States carbon steel, the appellate body repeated that the task of ascertaining the meaning of a treaty provision with respect to a specific requirement does not end once it has been determined that the text is silent on that requirement, which means silence does not necessarily mean waiver of exceptional clauses. So here we can see that the dissenting panelist raised another following argument. Since in some other cases, even if there is no cross-reference, still members of WTO organization are still entitled to invoke as defense for some of those breaching measures. For example, no party in this dispute has any doubt that China must comply with GATT Article 1, the most favorable nation principle, even though there is no reference to Article 1 of the GATT 1994 in paragraph 11.3 of China's accession protocol, which means if China's measure it's not against General Article 20, but in the case Article 1 of GATT, most favorable nation, so still China could invoke this article. And now let's move to the second opposed pair of context. It's about the canon of effectiveness. It goes to those paragraphs which have expressed contextual links to get Article 20. So the most obvious evidence comes from the two adjacent paragraphs nearby paragraph 11.3, that is 11.1 and 11.2. In both adjacent paragraphs, you can see that there is expressed textual link to get Article 20. And in the end of both paragraph 11.1 and 11.2, we can see there is a link said like in conformity with the GATT 1994. So by this evidence, the majority made the argument that there is an intentional negotiation between China and other WTO members. By the contrast between the first two paragraphs and the third one, the omission in the third paragraph means China has intentionally waived its right to invoke the general exception. But the separate panelists, I mean the dissenting panelist, still here comes to another counter argument. It said that there are situations in which an acceding member expressly waives its right to invoke certain exceptional clauses. That, in other words, there are also evidence suggesting that if a country has the intention to waive its right to invoke some exceptional clauses, it will expressly establish such kind of waiver. The evidence comes from paragraph 3.7.3 of the protocol, which says that China shall, upon accession, comply with the TRIPS agreement without recourse to the provisions of Article 5 of the TRIPS agreements. Article 5 of TRIPS agreements is a similar kind of exceptional clauses, and it has the same function of get Article 20 for those general exceptions. So you can see here for the point of view of the separate panelist, in this case here, China has expressly stated that it will give up the right to invoke some exceptional cases, which means if China has the intention to waive its right to invoke exceptional clauses, it will expressly say it in those clauses. But in the case, let's move back here. Although there is no express waiver in 11.3, this does not mean that China has given it up. And now let's move to the third opposed pair of context. It relates to how to use the preparatory work for the protocol, which means China's accession working party report, how to take those preparatory work into consideration when interpreting the clauses in those protocols. Here we can see that there is one paragraph in the preparatory work. So this is kind of a novel argument raised by China in China Rare Earth in its panel decision. China said that in 170 of its working party report, it says that fees, charges, or taxes levied on imports and exports would be in full conformity with its WTO obligations, including Article 1, 3.2, 4, and etc. So here the wording including means a non-exhaustive listing of those exceptional clauses that China could invoke. So here if we combine paragraph 170 with paragraph 11.3 of the protocol, which means that the charges or taxes levied on import and exports they're still able to invoke the general exceptional clause in GATT Article 20. But the majority of those reports hold it different. What's the reason? Can you see here? The reason is that paragraph 170 is located under section D of the working report, which is titled as Internal Policies Affecting Foreign Trade in Goods. For the majority, the section of number D is not applicable in China's case of export duties on rare earth and rare materials, but rather it is section C, which is titled with export regulations, that is relevant to the case at hand. Since if we go to paragraph 155, in which there is no express textual link between GATT Article 20 and paragraph 11.3 of protocol. But the dissenting opinion, the dissenting judge might have another counter argument against the majority. If we go to the subsection, the titles of the subsection of number C and number D, we will find that the subsection 2 under section C, which is titled as export licensing and export restrictions, that is the same as that of the title of the section in protocol, I mean paragraph 11.3. So for this argument, it is 164 that is really relevant to paragraph 11.3 of the protocol. So anyhow, the basic point here I want to make is that by contextual inquiry into those treaties of those articles, we are likely to find in those hard cases two sets of competing contextual arguments, but the appellate body and the panels never decided to respond to the question why the DSB chose one set of contextual arguments instead of another. And so if that is the case, we come to a dilemma. We can see the limits of contextualized ordinary meaning. Context is itself a notion of multiple versions. It depends on how broad we go to pick up context. So it's about the context of the whole sentence, the whole paragraph, the immediate adjacent paragraphs, or the whole subsection. It depends on how far you go to approach those contexts. And the second problem is that even if for the same context, there might be two competing interpretations of the same argument, and then it's about just brief reflection on how to work out of the dilemma of the contextualized ordinary meaning. One way, as some of those recent literatures have suggested, is that it's for the DSB to take a further step to explore the objects and the purpose of those treaties, to make up the gap of WTO treaties, like solving the incompleteness of those contracts in domestic law. Like there are some retired WTO AB members, like Ms. Lilia Batista said that she wishes that there might be more explicit provisions on special and differential treatment for some kind of developing countries. They hope that they could have some kind of stronger judicial function in interpreting those treaties. But still, for the majority of those members, they're concerned of breaching their long-term commitment to establish a member-driven dispute settlement body. Like the former Judge David Unterhalter said that if a member of the WTO can't agree as to how they wish to take the multilateral project forward, the virtues of the settlement body will not be saved from their dissatisfaction, like the opposing pairs of contextual arguments. So my concluding observation is that perhaps there is no quick fix for the dilemma of contextual interpretation in those hard cases. So the puzzling contextual interpretation is likely to continue in the years to come. One of the primary reasons is that perhaps now those big countries is likely to accept a stronger judicial functioning of those of the DSB institution. But here still we need to wait and to see further cases and further reports on similar issue. Okay, thank you.
Thank you, Professor Xiong. What he talked about is a very complicated issues in the WTO dispute settlement system, and I think how the appellate body play a role in this system now has no answer yet, and we look forward to how the major members, including China, EU, and US, and India, and so on, to get a compromise and get a clear answer. Thank you, Professor Xiong. And now, Professor Hu from Shanghai Jiao University, please.
Thank you. First of all, I would like to thank the organizer of this conference to invite me to be here to give the speech. This is the first time. This is the second time for me to Copenhagen, but the first time to give an official presentation here. My presentation today is just to follow the outline of a research paper which is expected to submit to the organizers of this conference. But since the article is still unfinished, so today my presentation is mainly to open the questions, not to give the answers to the questions. The title of my presentation and also the research paper as well is Alternative Dispute Resolutions in the Implementation of One Belt, One Road Initiative. If we take a retrospective view of the Belt and the Road Initiative, now we can simply conclude it is part of China's continuous process of opening to the world. This year is the 40th anniversary of China's opening to the outside world. Since 1978, China has decided to open its door to the world, and we can divide this period of 40 years into 4 stages. For example, the first stage is the first 10 years. At that period, China simply opened its door to attract foreign investment. Almost no Chinese FDI goes abroad or went abroad. And the second stage, since the 1990s, there were a little Chinese enterprises to go abroad, but mainly, or most of them, are state-owned enterprises. Then the third stage started from the year when China entered the WTO, the World Trade Organization, which is 2001. So since then, since China became a member of the World Trade Organization, the communication became mutual, that while we attracted the foreign investment, we also encouraged the Chinese enterprises to go abroad, both the state-owned enterprises and also many private enterprises. And finally, the fourth stage, since China announced the Belt and the Road Initiative about a few years ago, so China has entered into a new stage of the opening policy. So now we encourage more Chinese enterprises to go abroad. So in the recent years, perhaps you have noticed a very interesting change in the number of the FDI. China, for the first time, actually, the out FDI is more than in FDI. That means China have invested more abroad than we received the foreign FDI in China. So this is a big change. This is almost a fundamental change in China's opening policy or in China's opening process. Yes. So now these are the preliminary issues for my presentation. Now the first part of my research is Belt and Road Initiative and Dispute Settlement. One Belt, One Road Initiative and possible disputes. Now, first of all, let's see. With the increasing of trade relationship and investment, it is quite predictable there will be more and more disputes concerned with all of these economic issues between China and all those partner countries. So, what types of disputes will be? Now we can see, or we can conclude in these simple ways. Now, first, dispute between states, yes, still are part of the disputes because of the different understanding or different interpretation on the international treaties, like the presentation just now Professor Xiong gave us. China has a lot of disputes in the WTO, actually one of the most active participants of the DSB. So there will still be many disputes between states, but at the same time, there will be state disputes between enterprises. Yes. So this is the second type of enterprise disputes concerned with the Belt and the Road Initiative. And the third, even the dispute between a state and an investor or an enterprise. Yes. So there will be many types of disputes in future while we are implementing the Belt and the Road Initiative. Now, this is the brief introduction of my research paper. Then the second part is existing dispute settlement mechanism and their problems in the application. Now, how useful are these existing dispute settlement mechanism? Just now, Professor Chen Li has already told us a very important issue. Actually, is a problem how to apply the arbitration decisions made outside China. If it is not made by an institutional arbitration body or by a temporary arbitration. So there will be many such issues which we need to take it into serious consideration. Now, the first issue in this part is WTO and trade disputes. So WTO rules and dispute settlement mechanism still apply to the WTO members, especially for those issues in interpreting the WTO rules or WTO agreements. But there are some partner countries along the One Belt, One Road, they are not WTO members. Now, for example, I just came here yesterday from Serbia, and Serbia is one of the partner countries in One Belt, One Road Initiative. Actually, Serbia is an active participant because this country urgently needs investment to help them to build the facility constructions. But Serbia is not a WTO member so far. So how to solve the problems, how to solve the dispute between China and those non-WTO members, even in interpreting the governmental agreements. So perhaps they can or they may resort to the regional or bilateral trade agreements. Maybe this is one possible way to solve such problems. And the third is dispute settlement case by case. Maybe this is a more practical way to solve the problems in One Belt, One Road initiative in quite a long time, because it's not realistic to set up a complete legal structure or even a legal framework for all those partner countries. Now, so far, according to the official statistic, there are altogether 66 partner countries within this initiative. So it is not realistic to set up a comprehensive legal structure or even dispute settlement mechanism to solve all sorts of disputes concerned with countries. So perhaps this is a practical way to solve the dispute case by case. And the second issue of this part is exceed and its investment dispute settlement. Yes, the Washington Convention signatories may or may not choose. So even those signatories, they still may not choose this body as a dispute settlement center. So, but anyway, this is a very important way for them to solve the investment issues, but it is not the best one. So others may resort to regional or bilateral dispute settlement mechanism, either bilateral or regional. So maybe these are the more practical ways for these partner countries to solve their investment disputes. And the third section of this part is existing dispute settlement mechanism within the regional trade blocs. Yes, there are some regional trade blocs, and China has participated in some of them, in the actives of some of them, but there are still some problems for both China and other partner countries to apply this mechanism. Now, first of all, the non-litigation tradition. Most Asian countries are influenced by the Confucianism, and the essence of the Confucianism is what? Is harmony. Is harmony, not dispute settlement body. So non-litigation tradition is still one of the most important elements in many either bilateral agreements or regional agreements in Asian countries. So this is one issue of this part. And the second is current regional cooperation. Yes, there are some regional cooperation like RCEP, like CAFTA. Yes, but if we look at these agreements carefully, we will find there are seldom articles concerned with the dispute settlement. And the fourth is energy trade dispute settlement and its own problems. Now, energy trade is a little different from the trade of goods because most energy trade is carried out between the governments. And China and some other partner countries are also important participants of the energy trade, like China, Russia, and other European countries. So how to solve the problems, how to solve the disputes arising from the energy trade? There's still some problems. First is the Energy Charter Treaty. Yes, it was important for many countries, including Russia. But unfortunately, we know Russia withdrew from this organization or withdrew from this charter 2 years ago. So that means this charter now do not bind Russia. And China has signed the agreement, but has not ratified it so far. So on the other hand, this treaty does not bind China either. So what is the legal means for those countries to solve their trade disputes. At this moment, perhaps we can only solve this dispute still case by case. We cannot solve this problem under a certain international organization or according to an international treaty. Then, dispute settlement mechanism for financial disputes and the bottleneck. We know with the One Belt, One Road initiative under the sponsorship of China, now we have set an Asian Investment Infrastructure Bank, or AIIB. Now this is an international financial institute without T's. It's unlike the World Trade Organization, because the World Trade Organization, we know the WTO rules are binding all its members, especially with its dispute settlement mechanism. So AIIB is an international financial institute without such an international dispute settlement body. So without this, even the rules are not binding its members. So the second issue is WTO still focusing on the trade issues. So the pure financial issues are not relevant within the WTO DSB. So ICSID might be relevant because many financial disputes are connected with investment, but it's possible for all the partner countries, maybe or may not be. Now, the third part of my speech is paper is different settlement mechanism for different disputes. So maybe this is one practical choice or one practical alternative. So different mechanism for different disputes. First, specific dispute settlement mechanism for trade disputes. Now we can at least follow these following choices. For example, one is an efficient choice for WTO dispute settlement. Yes, so far, WTO dispute settlement body or the dispute settlement mechanism is still one of the most efficient ones to solve the disputes concerned with at least the WTO members. And the second choice is a supplementary choice is those regional organizations or the regional agreements like RCEP and CAFTA and so on. But we need to give more. We need to improve the contents of these agreements, especially to add some dispute settlement articles or provisions into these agreements. And the third choice is a possible choice is the ongoing negotiations between China and some other partner countries like China Gulf Cooperation FTA is ongoing, and China CEEC, this is a new type of cooperation between China and 16 Eastern European countries, which is called 1+16. So this is the annual dialogue between China and these 16 Eastern European countries. The recent one, the last one was held 2 months ago in Bulgaria, yes. So we can improve or we can give more elements or new elements to this cooperation, including the dispute settlement mechanism applicable to those particular countries. So they are the alternative ways. And second section of this part is AIIB may be a useful means for the resolution of investment disputes. So as I mentioned just now, many investment issues are connected with financial issues or vice versa. Yes, vice versa. So dispute settlement body, the point is the dispute settlement body in future AIIB is permanent or temporary. If they're still not a permanent dispute settlement body or arbitration body or institution, then the temporary arbitration, like the articles of AIIB provides at the moment, can be accepted as Professor Chen raised the issue or raised the question. So to be or not to be, this is a problem. So the second is dispute settlement decision, enforceable or negotiable. So, okay, so unlike the WTO, so WTO is the dispute settlement body with teeth, and the decision is enforceable. So whether it is possible. So the third is financial disputes may be settled together with investment issues. Yes, so AIIB arbitration is a possible choice, but we need to do more for this. Then the fourth part of this article is arbitration or judicial means to be or not to be. So arbitration, who made the decision? Temporary or permanent body? So since Professor Chen has discussed a lot about this issue, so I just left out here. So the second is how is the decision enforced? Yes, connected with the previous one, whether or not it is enforceable. Then second issue, a second part of this section, second section of this part is judicial means who made the judgment? Chinese courts and foreign courts. Yes, of course. Then how is the judgment enforced? Now we can follow the Chinese Civil Procedure Law and even the New York Convention. Oh no, sorry, New York Convention is only for arbitration. So we can only follow the Chinese Civil Procedure Law. So, conclusion. Now, one is disputes may be concerned with trade, investment, finance, and other issues. Second, no single dispute settlement mechanism is available for all sorts of disputes. Third, how is a dispute settlement decision enforced? It depends. It depends a lot. It depends on the willingness of the government. It depends on the efforts of the lawyers. It depends on everything. So, my conclusion, the final sentence is, all these efforts we made here, we have made so far, is one small step for the Silk Road. But this is a giant leap for the dispute settlement. Thank you very much.
Thank you, Professor Hu. And this topic is a very hot topic now in China. And Professor Hu gave his own explanation to this question. Thank you, Professor Hu. And now we almost have no time for questions, but I think we should have time for questions and answers. We have 3 questions. Oh, there first. Thank you.
Thank you. A short question to Professor Hu, if I may, about energy charter which was mentioned. China has not ratified. Has provisional application of energy charter been ever considered by China? Provisional application before it is ratified.
Do you mean the energy charter?
Yes.
China, unfortunately, China has just signed the agreement. China has not ratified officially this treaty. So, which means that this treaty does not apply to the energy trade disputes involved China. Yeah. Pardon? Provisional arbitration.
Provisional application.
Provisional application. Yeah. So, but then back to other issue is, see, actually, Russia is the most important trading partner with China on energy trade. So, but if the energy trade treaty does not apply to Russia, this charter is almost irrelevant. It's,
Given what happened to Ukraine, I think China will probably not.
yeah, I agree with you. Yeah.
Thank you very much. So my question is about WTO law, and it's for Professor Bingwan Xiong, who gave a very good and precise presentation. So what I want is basically to two little clarifications. So what I take from your presentation is that in the rare earth appellate body decision, what we've got is a kind of much needed clarification, with some doubt still about the use of the context in order to interpret or to use the ordinary meaning. But I would say that on the positive note, what's now clear is that a case-by-case analysis is required to determine the specific relationship between an individual provision in China's Action Protocol and the GATT 1994. I think we can agree on that. Now, from there, the two little questions I have are, first, number one, although the appellate body decision deals with GATT only, I think we can assume it has implications for other agreements, like the one on subsidies, and how the subsidy agreement relates to Article 20. I'd like to know what you think about that small thing. And the second question is, beyond China itself, we can think of all the next acceding countries, and there are many that are now in the process of acceding WTO law. Would you agree that they should make a reference to Article 20 in all provisions that they want to be covered by the Article 20 justification? And practically, if you were to advise these acceding countries, would you tell them, play safe, and whatever you agree on in the accession protocol, you got to make clear that this can be subject to Article 20. Do you think that this would remove some uncertainty? Because otherwise, it will be up to the appellate body to interpret, and as I said, on a case-by-case basis, which is not that predictable. Thank you.
Thank you very much. Very nice question. So perhaps I could proceed with the second one. Yes, as you said, there have been many countries, many acceding members who have taken the situation of Chinese cases into consideration, like Russia and Ukraine, when they when they prepare their acceding protocols, and they have added many express links into their protocols. Perhaps part of their consideration comes from the disputes related to China, if that is the case, I mean, if the technical such kind of absence equals waiver is the foundational interpretive technique for the DSB, it will, as you said, will make huge costly efforts for those acceding members. You have to write down in each of those clauses that if you are going to waive your right to invoke general exceptions, or if you are going to have such kind of express link to those general exceptions. So here, my basic point here is that my whole inquiry into those contextual interpretation documents is partly related to my education in the States about the critical legal scholarship. So one of the essential arguments for critical legal scholarship, and that's kind of similar to the legal realism in Scandinavian region, that those formalistic arguments in some of those hard cases do not work to figure out the real intention or the purpose for the original signatory of those treaty members, or in domestic law for the contractors of those contracts. But for your first question, I have no clear point yet. Perhaps we have to wait and see. Thank you.
Who should I?
Thank you. I just have a quick question for Professor Hu. Thank all the presenters for their excellent presentations. And it's something which occurs to me in relation to the Belt and Road. If the Belt and Road is an initiative rather than a policy or a strategy or a plan for a regional grouping or anything of this kind, why is it necessary to have all these discussions about Belt and Road dispute settlement? Normally, in a commercial context, you have a number of parties who agree to, say, build a road. They consider mandatory legal requirements in, say, Kazakhstan. They determine what law they're going to apply. They negotiate the contract. And in the course of those negotiations, they consider their various options and then come up with a location and plan for dispute resolution. So why is it that there is this concept that there needs to be an overall Belt and Road plan in relation to dispute resolution when you're dealing with countries which start in China, move over as far as Georgia, and then go down through Asia, where you have a whole range of different legal systems, some of them very sophisticated?
Now, I would like to answer your question with two simple ways, simple reasons. Whereas with the implementation of One Belt, One Road initiatives, there will be huge amounts of money investing in this initiative. So this is the first reason why we should set up a legal framework or something like a dispute settlement for those specific disputes. And the second reason is, this time, Belt Road Initiative is different from all the previous China's government support to other countries. Because in future, actually, most of the investment come from the private enterprises, not from the government. So we need to protect the interests of the enterprises. So that's why dispute settlement body is important in this means. Unlike that of the 20 or 30 or even 50 years ago, most China's investment came from the government. So at that time, maybe friendship is the first, interest is the second. Even if the Chinese investment was lost, but friendship is still existing, so it's okay. So we did not pay much attention to the settlement of the disputes at that time. But now the situation is different. Most investment come from the private enterprises. We need, actually, it is also the responsibility for the government to protect their interests, because many Chinese enterprises go out to invest abroad simply under the encouragement of the government. So that's why it is also the responsibility for the government to protect their interests. Okay?
Thank you. Thank you all for thank you three speakers and thank you participants. Time is always valuable treasure, and I'm sorry we have no further time to further discuss, and I think our session is over and we have a coffee time. Thank you.